and welcome everybody. As Gina said, my name is Max Sneed. I am at the law firm of Kerr, Russell and Weber, and I chair our intellectual property practice group. And today we're here to talk about how to protect entrepreneurs and their new businesses, their ideas, how to protect themselves, and how to protect their ideas. So let's jump right in. You are an entrepreneur, you have a great idea, you have an idea for a niche business that has been underutilized, or you have an idea that is novel, no one else has thought of it before, but it's an idea in your head. What do you do next? And the most prominent takeaway I'd really like to talk about today is to do everything that we talk about as soon as possible. You want to protect your idea, you want to protect it from others stealing it, but you also want to protect yourself, and you want to make sure that your idea is protected in that you make sure it's available. You make sure that no one else has gotten there first, because that kind of trouble down the road can be very disruptive and very expensive. So I really want to get across the idea to protect yourself and your idea early and determine whether what you have is in fact protectable from the get-go. So one thing that is surprising to a lot of people is that the law doesn't really protect an idea. If the idea is a mere idea and not reduced to practice, not used in commerce, not expressed, it is not by itself protectable. We need to find a way to protect your idea under the law. And there are a variety of ways depending on where you stand and what your idea is. Is it a trademark? Is it a copyright? Is it a patent? Perhaps it is a trade secret, and there are laws and in common law that protects trade secrets. And failing any of that, if it doesn't fall within a statutory protection, you will probably want to explore protecting it via a contract, a non-disclosure agreement. So let's talk about each of these aspects of intellectual property and how to protect your idea or your new business. So trademarks. Trademarks are the primary way of protecting your name or your logo or your product name. So what is a trademark? I think it's surprising to me how many, even lawyers, don't know really what a trademark is, or the difference between a trademark and a copyright. And in its most basic form, a trademark identifies the source of a good or a service. If you see the Coca-Cola on here, you know that the Coca-Cola company supplied this good. If you see Amazon on the box that you arrived at your house, you know that Amazon was the source of that delivery service. Amazon is largely a service, so the Amazon mark is a delivery service. It can also be goods. Amazon actually has its name on some goods as well. Trademarks can identify both the source of goods and services, and the most common types of trademarks are word marks, like the word Amazon, design marks, like the Amazon logo with a smiley face, or again, the Coca-Cola. There are two trademarks you're viewing right now. The script Coca-Cola, the way it is presented is a design mark, but the words Coca-Cola, that's a word mark. There are two separate marks, both owned by the Coca-Cola company, and both designate that the source of the product is the Coca-Cola company. Commonly, for an entrepreneur, you'll probably want to get a registered trademark for the name of your company. In the digital age, the name of a company, and just as importantly, the domain name that you use are really important. You may have different products under that name. For instance, the Coca-Cola company also sells Sprite. That's a different registered trademark of the Coca-Cola company. But you're going to want to make sure that the name of the company And it doesn't have to be, by the way, the official name that's registered with the state. That can be the name that you present to the public, but a trademark is the name that is presented to the public. It could be a DBA. You could be doing business as. Some companies, for instance, Subway is owned by the Doctor's Company. That's the name of the owner of the trademark Subway. But they don't use the Doctor's Company. The trademark is Subway, even though that's not the name of the company that owns that mark. So names of products, names of services, names of companies, and again, there are design marks and there are word marks. A design mark doesn't have to have words as part of it. It could be just the Nike swoosh. That is a well-known design mark. You don't need any words to know that that swoosh is owned by Nike, and if you see it on a product, you know that Nike is the source of that product. So that's the basic gist of trademarks, is they identify the source. And it can be other things. It can be a slogan. McDonald's has the slogan, "I'm loving it." Doesn't say McDonald's on it, but you know if you hear the phrase "I'm loving it," likely it is designating McDonald's as the source of restaurant services. Even something like a sound can be a trademark. When you hear the little chime for Intel during a commercial, you know that chime is related in your mind to Intel. And so that chime is a trademark of Intel. It designates the source of those chips. When you hear it, you think of Intel. And even on rare occasions, a color can be a mark. The trademark office doesn't like to issue trademarks for colors because they don't want colors to be limited. They don't want somebody to have the exclusive rights to a color. But in certain circumstances, if that color is fanciful, if it doesn't really isn't necessary to the operation of the good or service, a color can be a trademark. The most common example of that is Owens Corning fiberglass is pink. No real reason for it to be pink, but Owens Corning has done a really nice job of advertising that its fiberglass is pink. If you see pink fiberglass insulation, you probably know that it's Owens Corning, and if somebody else came out with pink insulation, that would be confusing. And so Owens Corning is the exclusive user of pink fiberglass insulation. The other common example of a color that's a trademark is in sugar substitutes. Everybody knows the little white packet is sugar, the little blue packet's one kind of artificial sweetener, and the pink packet is a different color, a different source of a different kind of artificial sweetener. So those are rare. Most commonly, trademarks are words or designs, but it can be almost anything that designates the source of a product or a good or a service. So again, going back to my theme of know where you are early, find out where you are early. Before investing the time in branding, before investing in getting a domain name, you want to know up front whether it's available and whether it's registrable. Just because there's no conflict doesn't mean it can be registered. The most common roadblock besides a pre-existing conflicting mark is that the mark that you've chosen is merely descriptive. And the Patent and Trademark Office does not want to give one person the right to describe their goods and services. That would be unfair to competitors. And descriptive, the phrase merely descriptive is maybe broader than you might realize. Geographically descriptive terms cannot be registered immediately. So if I have a software company and I want to call it Great Lakes Software, that is a geographically descriptive term. If I want to open a restaurant called Detroit Coney Island, that's descriptive. It's a Coney Island restaurant in Detroit. So a mark that is merely descriptive won't be registered, but there's an exception to that. And the exception is if you've used the descriptive term long enough and exclusively, you can then get what's called acquired distinctiveness. And so my mark for Great Lakes Software, if I go ahead and open my company called Great Lakes Software and I use it for 5 years and nobody else has come along to use it, I can then apply to get registration based on acquired distinctiveness. Yes, 5 years ago it was a descriptive term, but now that I've used it, the public has come to know me and know me under that name. I can then claim acquired distinctiveness, and I might be able to register that mark. Now that leaves you 5 years without any real protection against somebody else coming along and using a similar name, but that might be a calculation you're willing to take if you really like that name. It's merely descriptive. And you know, an example of a descriptive term that has become well known and registered is American Airlines. Decades ago when they started, you might not know that American Airlines was referencing a particular company. It's just a term that describes an airline in America. But now, of course, you know, through decades of use in advertising, everybody knows American Airlines is a designator of the source of airline services. And you can do the same. If your mark is descriptive and you use it long enough, you can then get it registered. And if that is the situation you find yourself in, the Patent and Trademark Office actually allows you to essentially park the name in its supplemental register. So for my hypothetical mark, Great Lakes Software, I could register it, I could try to register it. They'll say, no, sorry, you can't register it as a regular mark on the principal register, but we'll let you park it here on this supplemental register. And if you keep using it for 5 years, you can try to move it after 5 years. At that point, move it onto the principal register. So it's a nice tool. If you do have a mark you really like that's descriptive, you can park it for 5 years, use it, and eventually get registration. And I know what you're thinking, well, geez, I'll just choose a mark that's not descriptive. Well, that's easier said than done. There's a reason people choose a descriptive mark. I mean, especially for a new business, you want people to know what you do when they hear about your business. You know, for example, Xerox decades ago when it started, and you say, hey, I work for Xerox. Well, what does that mean? I don't know any idea what Xerox does. It's a made-up word. It's a very strong mark, easy to register it, but it's also hard to build up goodwill because nobody knows really what Xerox is. Great Lakes Software, you know, it's a software company, you know, out of the Great Lakes area. So there's a reason people choose descriptive marks. It's kind of a trade-off. You want to have some descriptiveness in your mark, but those are the ones that are harder to register. So the more concerning problem is, of course, if there is an existing mark that conflicts. And determining whether another mark conflicts is a pretty complicated process, but it boils down to one question. Is there likelihood of confusion? Does your proposed new mark confuse people into thinking you're related to an existing mark? And it has to do with how similar the marks are. They could be not identical, but so close that people will be confused. Or they could be identical, but be in different fields, and so people wouldn't be confused. The example on your screen is Delta. There are literally dozens of registered marks for Delta, but they're all in such different fields that people are unlikely to be confused. Nobody's going to think that Delta Airlines has suddenly started selling faucets. So they can coexist without likelihood of confusion because airlines and faucets and Delta Dental Plan are all different enough that nobody's really going to be confused. Now, if somebody were to open up a rental car agency called Delta Rental Car and put it at the airport, probably that wouldn't be registrable because it's pretty likely, or it wouldn't be surprising to consumers if Delta Airlines at the airport opened up a rental car place at the airport. Those fields are close enough and similar enough that likely Delta Rental Car would not be allowed. So we talked a little bit about, you might want to go ahead and use a descriptive mark, wait till you have acquired distinctiveness. There are good business reasons for doing that. The risk, of course, is that somebody else could come along using a same or similar name. There's really nothing you could do about it because they have a right to describe their product just like you do. So if you really like the name, you could take the risk, use it for 5 years, and then hopefully get a registration after 5 years. What would not be a worthwhile business risk is to use a mark that conflicts. There's just too much risk. If you invest in website and signage and business cards, and you could go years developing goodwill and then have the senior user come along and make you change the name. And if there's a true conflict, you'd have to change the name. And all of that goodwill is out the window. And even if it's a close call, litigation, trademark conflicting litigation is notoriously expensive. You want to make sure when you start the process, you're clear on your trademark. It's really important to get that done early, because abandoning a mark down the road after goodwill has been built up is a very painful process. I've seen it happen way too many times, and it's no fun. So the best advice I can give you is figure it out early. All right, so that was the bulk of the trademark. If there are any questions, we can address those now. If not, I can move on to patents. Patents. Go ahead, Gina.
We did have one question come in, Max. I don't know if you want to answer it now or wait.
Well, if it has to do with trademarks, I could answer it now, and if it has to do with generally, I could answer it later, I guess, instead of moving back to it.
Do you have any tips for people who are at the beginning of their business or idea phase, are looking to share their ideas with others for collaboration, advice, and guidance, but worry about theft of their idea since it's still in the early idea phase with no protection yet?
Absolutely. And I actually am going to punt on answering that because we'll get to that in a little bit.
Perfect. Thank you.
Okay. So patents are, I think, what most people think of when they think of protecting their idea. But again, it's really important to understand that the idea itself is not patentable and difficult to protect. A patent is typically a process or a machine or a composition, a new way of doing something, a new way of solving a problem, or the first time anyone's been able to solve a problem. It can be, basically you can stand on the shoulders of giants. You can use prior art as long as you're giving credit to the other patent owner, and then you can go ahead and improve on it and get your own patent. And that is a legitimate invention, but it does have to be new, and it has to be a solution to a problem. In order to qualify to be patentable, the invention has to be unique, can't be out there before, and that's actually a pretty significant hurdle. And it's really difficult for somebody who's not a patent attorney or in the patent field to figure out, to determine whether somebody else already has this idea. You can fumble around the Patent and Trademark Office website, and if you're technical and you know the right things to search for, you can do an okay job of trying to find something else. But to be really secure in knowing whether your invention is unique and new, you probably should hire a patent attorney or somebody who does patent searches to determine that. The next requirement to be patentable, it has to be non-obvious. That's obviously a bit of a judgment call, but it also is important because it protects there from being a world of patents out there stopping somebody else from doing an obvious idea. And so it's actually an important kind of restriction to make sure there aren't too many silly patents out there that will then lead to patent trolls who can try to stop somebody from an obvious fix and say, hey, that's my patent, you need to pay me. And then again, we already talked about reduction to practice. A mere idea in your head, you may have woken up from a dream and realized how to do cold fusion, but until you reduce it to practice, until you actually have the mechanism showing that it works in practice, you can't get a patent on it. I see, Gina, there's a question going back to how do I find out if a trademark already exists? It's a great question. I recommend, simple Google search is the easiest, cheapest way to start off on a patent search, sorry, a trademark search. See if anybody else is out there. That may or may not help you. The next thing to do is to look on the USPTO website. It's uspto.gov. Travel to the trademark section, and there's something called tests for trademark searches, and type in your name. Type in your phrase, whatever it is you're looking to trademark. But the tricky part is if you type in your exact phrase, that's not going to cover you. You need to type in similar phrases. You need to type in misspellings, common misspellings, intentional misspellings, similar words and phrases with suffixes and prefixes that are still give off the same commercial impression. So you really need to be as creative as you can in thinking of searches that might be confusingly similar to the public. And more than once, we've had somebody come to us with a trademark infringement question and say, geez, I looked it up, it was available, and they didn't look it up under all potential spellings, or they looked up just the exact phrase without a different suffix or prefix or surrounding words that are less dominant in the mark. So it's really important to be creative when you're searching to see if there is a conflicting mark out there. One thing that is, I put on the screen, didn't reference, but I will now, is if you are early in your process, the Patent and Trademark Office actually offers in the US, not in all countries, what's called an intent to use application. And so if you're unsure whether your mark conflicts, and you're so early in the process, you're not out there using it yet, but you're planning to use it, you can file an intent to use application. And it's just like a regular application, except for that you won't prove you've used it in commerce. And the Trademark Office will go through the analysis and see if it thinks it's registrable. If it gives you the go-ahead, then you're clear. And if it tells you that you're not clear, then you'll know to pick another name. And so that's something that is really useful for entrepreneurs who are at the beginning stages, who are thinking about using a name or a phrase or design. They can find out, while they're doing their process of getting it to market and getting it ready, the Patent and Trademark Office can be analyzing it. And then you don't get an actual registration until you actually use it. So if the Trademark Office reviews it, says this mark is registrable, at the time you actually use it in the sale of a good or the offering of a service, at that point you show a specimen showing you've used it, and then you get registration. But you have peace of mind knowing that once you do use it, you'll be clear. It is registrable. An intent to use application is a really useful tool for somebody in the early stages. And again, that way you'll know if the time comes that they look at it and say, sorry, there's somebody else conflicting, then you can switch gears and it's not too late. You haven't invested a lot in building up goodwill. Let's see. The question about trademarks and copyrights go together, I'll actually get to that in a little bit. And then what countries does the US trademark cover? Good question. A trademark in the US covers the US. Now, the good news is there's something called the Hague Convention in most countries. And most recently, Canada finally joined it. But most industrialized countries are signatories to the Hague Convention. And so through the US Patent and Trademark Office, a different section of the website, you can file for international protection. Excuse me. And it's a different charge, different amount, depending on the country. But most countries do allow you to register through the USPTO and through the Hague Convention for protection in other countries. So that was a good question. Okay, I'm going to switch to copyrights now. And again, let's start off with what is a copyright. Copyright, in its most basic definition, it protects original works of authorship. So original is key. Obviously, if you didn't create it, then it's not original and can't be yours to copyright. Authorship is a pretty broad term, and copyrights have become much more important just in the time I've been practicing law basically because of the internet. YouTube, TikToks, music sharing file sharing services. All of these things involve copyrights, and takedown notices have become really important. Copyrights have really grown in importance. The legislature, the federal legislature, recently updated the copyright law to try to keep up with some of the changes that have been going on, with the advent of the internet. So, the one thing that is maybe less obvious that a copyright protects is software. Now, copyrights protect books and movies and music and videos and plays and sculptures and artwork, but it also protects software. And for entrepreneurs, software is often really, really important. The code itself is an original work of authorship. And so something to protect is your source code. Really important to protect it. Interesting thing about copyrights is there is some protection for a copyright as soon as it is put in a medium. So as soon as you record that video on your phone, as soon as you send a text message could be protected as copyright. As soon as it is fixed in a medium, it is protected, and nobody can copy it legally. Where they get you is you can't sue for copyright infringement unless it's registered, but they allow you to retroactively register it. Now, the reason for this, if you think about it, makes some sense. It would be really unruly and impractical for every copyright protected work of authorship to be registered. Every day, every newspaper puts out new articles and new content. Every day, people are writing, writing things down that are protected. Every day, people are creating TikToks and videos and uploading them to YouTube. It would be unwieldy to expect everybody to put their content, register their content with the Copyright Office. So, if you have content and you later find it has been stolen, copied, then you can retroactively register it and sue. But the best thing to do, unless it's a really, really valuable work of authorship, is to not do the trademark registration right away. Send a letter saying, stop it, or I'll have to sue. And if all you're interested in is having the infringement stop, that's probably the cheaper, quicker route. Now, there are some instances when registration upon creation make a lot of sense, and those are the really valuable pieces of copyright. Things like feature films, novels, and really valuable software code. Those things, if they're the core of your business, they should be registered right away. And that way, when somebody does violate them or infringe them, you can sue right away without having to wait till the registration comes in. But more importantly, that's where the real damages come in. The monetary damages are available to somebody who had a registration at the time the infringement took place. And registration actually is pretty affordable. It's only around $50, depending on exactly what it is that's being registered. Now, there is a situation where if somebody is infringing on your unregistered copyright and you need to get it registered, they'll charge you about $800 for an expedited registration so that you can then go ahead and sue. So it can be expensive to get an expedited registration so that you can sue, which is again why it might make sense just to seek, send a letter asking them to cease and desist from their infringement. And more often than not, they'll be scared away and they'll stop their infringement. But for the really valuable works of authorship, typically software, movies, books, those things, it does make sense to register those right away. So that's the way to protect your own copyrights. But more often than not, when I'm dealing with copyright, it's on the wrong side of it. It's so easy in the internet age to copy others works. It's right there on the internet. You're creating a website. There's a beautiful picture you saw on the internet of the skyline, the city skyline that's just perfect for your website. And so you put it up there. It seems so easy, but that's likely subject to copyrights. And it's gotten so much worse because you've heard of patent trolls. Now we have copyright trolls. People will put their images out there, make them easily found, but they're subject to a registered copyright. And there's something called a reverse image search now, where if somebody owns an image, they can upload it and have a bot scour the internet to see if somebody has used their image. And then they will send a letter saying, you are using my image, you owe me royalties. It's gotten really bad, and it's a bit of a scam, but it works. If you have used somebody else's image or artwork or quote without their permission, they can force you to retroactively pay for it. So please be careful. There are sites that offer images and quotations and music that is in the public domain. So if you use images that aren't yours to own, make sure that you have confirmed that they're in the public domain or that you've gotten permission from the owner. If you really, really like a picture, the owner will license it to you. It'll cost you something. Same thing with photos or names of individuals. Don't do it unless you have their permission, particularly celebrities. Don't put some famous person's name or quote on your materials without their permission. Something that's maybe less obvious, but let's say you want to use a non-disclosure agreement, but you don't know how to write one. Well, you had to sign one last month, so you just change the name and use the same form that somebody made you sign. Well, that's technically somebody's original work of authorship, somebody like me. And so you really want to be careful. Technically, chances of you getting busted for something like that aren't very high, but you're better off, using either something that you purchased or paid an attorney to create or find out is in the public domain. Another maybe less obvious pitfall is formatting. If somebody has a really nice border and a particular set of flowers at the top and arranged a distinctive way, that distinctive formatting is protectable. And so just because you like it doesn't mean you should copy it. Come up with your own. You can do it. And that way, if somebody copies yours, you'll have the rights against it. All right, so moving on to trade secrets. If what you have doesn't neatly fall within a trademark or a copyright or a patent, it could still be a trade secret. And sometimes it can be both. It's pretty common. For instance, if you have a design for a new electric motor for automobiles, that design could be subject to a patent, but you also don't want to get it out in the public before it becomes, goes into production. So that should be protected as a trade secret. The key to a trade secret is it has to be valuable by virtue of it remaining confidential, and the owner of the trade secret has to take reasonable steps to maintain the confidentiality. So in your company, in your business, if you have information that is, valuable by virtue of it not being known to your competitors, make sure you keep it secret. Trade secrets are subject to statutes. They're governed by statute. Most states have adopted what's called the Uniform Trade Secrets Act. And more recently, the federal government passed the Defend Trade Secrets Act. They're pretty similar in terms of the way they define trade secrets. And again, the key is it valuable information? And is it valuable because it's not publicly known? And is it available to the public? If I can do a Google search and find it, it's not a trade secret. And if I didn't do enough to protect it, if I didn't make it password protected, or if I let anybody in my business see it, it's probably not a trade secret. So if you have trade secrets, protect them by keeping them secret, making sure that only the people that need access to them have access to them. Sorry, going back to a question here, I see. Going back to copyright. Should copyright statement on web page have start date to current date or just current date? Really, if the current is what you're trying to protect, it's fine to just have the current date. To be very honest, the little circled C at the bottom of your web page doesn't really confer any rights. It's a good idea to protect your copyrights in the sense that others will know you're serious about your content, and they'll know that you claim copyrights in it, you claim it's an original work of authorship. But honestly, the little circled C does not by itself confer any rights. It's more of a notice to the world that, hey, don't copy this. So the year next to it is really not that important, to be honest. Can you quote and give credit for a chart, etc.? If you are using somebody else's chart that you found on the internet, there's such thing as a fair use. If you're using it and you're using it factually and you're not using it as your own and you're not trying to sell anything by virtue of that chart, it's usually a fair use if you give credit. Most importantly, don't claim it as your own, and you know, don't use it as if it was yours or as a commercial enterprise. If it's just factual and you're just providing factual information, you're probably okay as a fair use on a chart, again, giving credit. And then, you know, trade secrets kind of goes back to one of the previous questions about how to protect your idea early in the process. And the way, you know, it may or may not qualify as a trade secret, but in order to help bolster the argument it's a trade secret, or even if it's not a trade secret, non-disclosure agreements are key. These things, you know, you may have seen one that's 15 pages long. It doesn't need to be 15 pages long. It can be pretty short. It can be affordable. But, you know, as was kind of implied by the question we got a little bit earlier, they're really important early. You may have shared your idea with your roommate or your friend or your family, but the best way to do it is to not share it with anybody unless they have signed a non-disclosure agreement. You really need non-disclosure agreements when you're starting your process. You might need somebody else to help you design an aspect of it. You might need somebody else to design your logo. You might need somebody else to see if it's actually marketable. You know, to get an idea off the ground, it's rare that somebody can do it by themselves. A simple one-page non-disclosure agreement is really important. It's enforceable and could be your best friend. It could be your new employee. It's a really good idea to get it in writing. You know, partners, contractors, investors, anybody that you share the idea with, non-disclosure agreement is a really good idea, and it's pretty easy. And, you know, going to a related point, any agreement or any collaborator you have really should be subject to an agreement. A really common example is, hey, I've got this great idea. I'm starting this business, and I need a logo. You're good at art. Can you draw me up a logo? And you know, if that's all there is, the logo comes back, love it. And 10 years later, you're a multi-billion-dollar company using a logo that your friend made for you. Now, your friend, technically, if you never bought that logo and never compensated that person for that logo with an assigned agreement, that person could come back and claim a lot of money in royalties. So something like that, anybody who's helping you, even if it's a friend, even if it's your family member, get it in writing. Establish the parameters of the relationship early. Everybody will know their expectations, everybody will know where they stand, everybody will be aware when, you know, a dispute arises. You can refer back to the contract and say, well, you know, here's what we agreed to back then. It's not only protecting your idea and your business, it's protecting relationships, because the ugliest, worst disputes are among family members or former best friends. And so if you set everything out early, all that stuff can be avoided. It's a little bit uncomfortable at first, but it's a really good way to save relationships in the long run. And so, contracts, there's a wide array of contracts you're going to want to do to protect yourself. You're going to want, with any employee, you're going to want a solid manual explaining rights and duties, and probably most importantly, letting them know they're an employee at will, and they are not, not subject to termination only for cause. So that way, hopefully, you can avoid a wrongful termination suit. If you have independent contractors, kind of the same thing. There's good reasons for using independent contractors as opposed to employees, but you want to make sure you're clear that they are an independent contractor, not entitled to the kind of benefits that employees may have. You want that independent contractor to be subject to a solid contract. We already talked about non-disclosure agreements, really important, especially early on. You don't want your best friend, or even somebody who you brought on as your first employee to leave after a month and say, I can do this myself and compete against you, which again goes to the next bullet point here is non-compete. Somebody who you brought on may leave after a month and steal your idea. So let's make sure that their agreement is that they won't go ahead and compete against you right down the street. If you are in the type of business that's going to have component parts delivered to you, or you're going to be selling to not directly to the public but to stores, you're going to want agreements with the store. You're going to want an agreement with the supplier. You're going to want to know, things like, is there a warranty on the parts? What kind of disclaimers are there? Do the parties, is there a limitation of liability? Is there an indemnification clause? If the supplier was at fault, will they indemnify you when you get sued? All these kinds of terms and conditions are really important to know early on. A lot of entrepreneurs are often presented with some standard terms and conditions and feel kind of bullied into signing them. Well, don't. Look at them carefully. If you have access to an attorney, if you can afford an attorney, please have an attorney look them over and push back. You're not obligated to sign something that somebody put in front of you. This is something you're going to be stuck with. And so you really need to make sure that you can live with these things. And going the other way, you might even be the one, hopefully you can be the one to present your terms and conditions to a supplier or to a customer. If you can, get your terms and conditions. If you can't, at least review their terms and conditions, know what you're getting into, and push back on some of the more egregious terms. Don't be afraid to push back on those. The last bullet point on this screen is website terms of use and privacy policies. I could spend a whole webinar on this, but just know most businesses these days operate partially or fully on the internet. And if your venture is going to be accepting money and taking down addresses, credit card information, email addresses, more and more, that kind of information is subject to protections under the law. In California, they have a, not all that new anymore, but they have the CCPA, which governs what you can do with and what kind of notices you need to give to those that have given you personal information. Same thing with any business in Europe. The GDPR has some strict requirements for anybody who's touched by a resident of the GDPR's personal information. You really need to be aware, if you're selling into the GDPR, selling into Europe, the GDPR is going to govern. Same thing into California, and a lot of other states have these kinds of laws bubbling up. So you need to be really aware of what you're doing with personal information. If you're sending out email, promotional type emails, you need to have an opt-out. If people are uploading information to your website, you need to have terms and conditions as to what can be done with those and who's responsible if they're violating some third party's intellectual property. Like I said, we could spend a lot of time on website terms and conditions and privacy policies, but especially if you are an interactive website gaining information from users, you really need to have a solid set of terms and conditions for your website. One thing that's a little bit off the subject of trademarks and copyrights and intellectual property, but I really, really want to make sure everybody's aware of it. And I think most people are, but I want to make sure. Create an entity. The morning you wake up with your eureka moment, the minute you have your great idea, the minute you decide that this is going to be a real thing, start a company. It's not that hard to start a company. It's not that expensive, but be amazed how early you can get tripped up. And if if you are talking to somebody and they give you some confidential information and you accidentally disclose it, that can be real liability. It can be really expensive. And if you have not started an entity to protect yourself, it can be really devastating. If you have started a company, the company will be liable. And okay, worst case scenario, the company is hit with a large lawsuit and it goes under and it never gets off the ground, but your personal assets are protected. Your house, your bank accounts, the liability will be solely with regard to the company. Now, that being said, when you open the company, when you start doing business, be smart. Don't commingle your assets. Make sure that you follow the corporate formalities because you don't want somebody claiming that the company was just a sham. But if you do it right and you open a company, the company should absorb the hit of liability. That's the very first thing you should do is start a company. Now, what kind of company? That's a different question. It depends on a lot of factors, including who your associates are, who else you're dealing with, investors, partners, etc. But as soon as it's more than you really do want your company to be operated under an operating agreement. You really want everybody involved, the officers, the directors, the investors, the partners, everybody to know where they stand on voting rights and dissolution and everything else that comes along with it. You really want to get an operating agreement as soon as it's more than one person, so everybody knows where everybody stands. Same thing as these other kind of agreements you're going to want in advance. An operating agreement will make sure everybody knows where they stand, and there might be a few discussions early on in creating the operating agreement, but it should help alleviate questions and hard feelings and litigation down the road. So again, what kind of corporation should you form? It really depends on who you are, who your partners are, what kind of business you're going to run. You really should consult with an attorney. Again, that shouldn't be a long and involved process. An operating agreement can be a little more expensive to get it right, but in terms of the initial consultations on what kind of company to form and the actual filing of the corporate form, it's not that expensive and it's very much worth it. One thing to note, going back to trademarks, you can name your company ABC Corp and never use that name in public. What's more important is the DBA. So whatever you name your company, first of all, it's easily changed, so don't worry too much about it. And secondly, the name that you present to the public doesn't have to match the company name. So again, more important to get the company filed with the state. It's not that expensive, but it's important to do it early. So I know I wanted to leave some time for questions, so I'm just going to run down the principal takeaways, which again, most importantly, do it early. Protect yourself early. Make sure that your name, your content, all that stuff is available to you, not owned by somebody else, registrable. Early on, form that corporate entity and get contracts in place, non-disclosure agreements in place right away. That way you'll be sure to be protected and everybody will understand where they are, where they stand, what their rights and duties are from the get-go. Again, maybe a little bit uncomfortable at first, kind of like a prenup, but better to have it when the time comes. All right, Gina, okay, a couple of questions I see. The name of the website where you can check to see if a trademark already exists. It's not foolproof, but it's the Patent and Trademark Office's official website. It's uspto.gov. And it's, again, the website for patents and trademarks. So in there, you're going to look for, click on the trademark link or trademark tab. And then there's something called TESS, T-E-S-S. And in there, you can search for trademarks, and you can search for them under a complicated search or the basic search. And again, in doing so, try to be as broad and creative as you can for anything that you might think of that the public might find to be confusingly similar. In addition, like I said, you do a Google search. We used to tell people to do a yellow pages search, but that's not even a thing anymore. But do a Google search, and again, a broad Google search with as many iterations of the name or similar names that you can think of. Okay, good question about a work made for hire statement. This is a copyright concept. In copyright law, some works are works made for hire. This kind of goes back to the question with regard to, hey, you want your friend to create a logo for you. A work made for hire is it's a statutory concept in the Copyright Act. There are a few things that are eligible to be a work made for hire. The easiest work made for hire is if the person that created the original work of authorship is an employee. Then if the work is in the scope of their employment, it is a work made for hire. But the specific question was whether the statement in a contract has any effect. It's a little more involved than we have time for here. There are, if you check out the Copyright Act, there is a list of specific matters that do qualify as a work made for hire, and as the question implies, they have to be specified as this is a work made for hire. What we do when we're drafting a contract for the creation, when a third party is creating content for the hiring party, the contract will essentially do belt and suspenders. It'll say, this is a work made for hire. If it does not qualify as a work made for hire, you still agree to assign all right, title, and interest to the work of authorship to me in exchange for what I paid you. So to answer your question, sort of, maybe, kind of, sometimes. But belt and suspenders is the way to go if you are having somebody create content for you. State that it's a work made for hire. There's no penalty for being wrong about that. And then say, if it does not qualify as a work made for hire, you will transfer, assign, everything else you need to do to make sure that I, as the person that's paying for this work to be made, own it. Okay, another question. Is it true that you or your company can be held liable for a lot more damages if your process idea infringes on a patent if there is evidence that you did a patent search ahead of time? If so, what is a safe way to search for patents without putting yourself at risk for owing more damages? That's sort of true. The best way to protect yourself is, if you knowingly violate a patent, then it's knowing infringement. The damages are worse. If you did a search and didn't find anything, but you did an inadequate search, I'm not sure how much of a defense that's going to be. As well, I searched, I just didn't find it. You need to get a patent search done. You really need to have somebody, unless you are really well practiced in that field, you need to have a qualified professional do the patent search. Patent attorneys will do it. There are some outfits that are not necessarily individual patent attorneys, but they will do a good job of a patent search. But you really need to get that done. I would not rely on just your kind of meanderings through the Patent and Trademark Office's website. New tech startup, selling software as a service, okay? Looking to protect the software. Is there a big cost difference for copywriting versus trade secrets? No, I mean, copywriting is inexpensive. If you have one code, if you have a valuable code, and this is your business, it makes a lot of sense in that case to get a registration. Registrations are cheap. They're only about 50, 60 bucks. They take a while, but if your business is centered around software as a service, yes, I recommend registering the software with the Copyright Office. Let's see, looking at the cost difference, if you are offering the software as a service, you certainly want to protect the source code as a trade secret, but and make sure nobody else has access to it who doesn't need it. But you're offering the object code to everybody. What you need to do is protect by contract. Make sure that only authorized users. So in your agreement for an end user, you want to make sure the end user only uses it for authorized usages and doesn't essentially resell it or make it surreptitiously available to the entire office if they've only paid for one license. Ideally, your code would allow you to monitor that, but if it's unable to do that, then you just have to do it by contract. And if you catch them, then you can force them to pay for the additional licenses. Okay, next question. Who is the best judge of whether your idea is different enough or too similar to move forward? A patent attorney, a patent searcher? Yeah, there are outfits that specialize in issuing patent opinions. I assume you're talking about patents here. So yeah, it's something that I personally don't do. I'm not a member of the patent bar. So yeah, we farm that out to a company that does patent searches for a living, and they're really good at it. So yes, a professional really should be the one to judge whether your idea is truly unique or whether it is essentially already covered by another patent. Okay, Gina, I don't see any other questions.